I don't believe that this is an issue that should be decided by the preferences of one judge. This is an issue for the people of Nebraska, and that I will work with the Attorney General here to continue to uphold the Constitution, and that we will continue to try to uphold the will of the people here of Nebraska. And with that, what I'm going to do is turn it over to the Attorney General to talk about the future of the lawsuit and where we go from here. Attorney General.
Thank you, Governor. This morning we have filed an appeal with the 8th Circuit Court of Appeals. We will this afternoon be filing a request from the 8th Circuit that they grant a stay, in effect saying to the state of Nebraska that the judge's decision, which is not to go into effect till March 9th, that be continued to be stayed until the 8th Circuit has a chance to fully consider the merits of the case. The reason we are appealing is because the 8th Circuit has ruled once before that this constitutional amendment is constitutional and upholds the scrutiny of the constitutional analysis. So it's been upheld once by the 8th Circuit. Also, the 6th Circuit Court of Appeals has ruled on a very similar constitutional amendment to Nebraska's and has found that in Michigan, Ohio, Kentucky, and Tennessee that their laws were also constitutional. So there is a good legal basis for this appeal. I think it's important to note in Judge Battalion's opinion, he chose not to make a decision as to whether or not marriage between a same-sex couple was a fundamental right. And I think that's the key legal issue. Frankly, I think most of us expect that the U.S. Supreme Court in June will rule whether or not same-sex marriage is a fundamental right. Judge Battalion chose not to. His analysis went more into a gender discrimination analysis and did not address that fundamental right. Our position is that under good, appropriate constitutional analysis and good constitutional law, for this issue is to be decided by the states. And for the states to decide it, they need to go through the very process that we went through in this state back in 2000, where 70% of Nebraskans found that marriage should be constitutionally determined to be that just between a man and a woman. If those who want to challenge that believe that it should be defined differently, according to our Constitution, the most appropriate method to do that is through the voting process, to have the public debate, to have the discussion of what makes best sense for families, what makes best sense for the state. Does it make sense for the state to then go into the process of defining all relationships? And where would you stop in that process? These are important matters of public debate. We don't believe it should be left up to one judge or a panel of judges. It's a matter that has to be debated among the people. And I say, as to Nebraskans, we're not going to give up that constitutional right. And so that's why we're going forward with an appeal, and we'll wait to see if the 8th Circuit hopefully rules on it before March 9th, because that will be the critical date. If they rule after March 9th, it can create some difficulty for us, but we're optimistic that the court recognizes that and will give us a ruling of whether they will stay the matter, and then fully consider this decision on the merits, fully evaluate Judge Battalion's opinion. If you have any questions, we're open to fielding those.
What do you make the 1 week delay? The reason 1 week delay was that the deal,
Judge Battalion commented from the bench at our hearing that he understood that there was a rational basis for us to seek the stay. When we raised the question of a 14-day stay, he goes, I understand, and recognized that other district courts have done that. I think what Judge Battalion was doing, technically it wasn't a stay. What he basically said is, my opinion will become effective on March 9th. I think he understood that by doing that, he gave us the opportunity to go to the 8th Circuit and seek the stay that we requested.
You're still seeking a 14 days?
Once we go to the 8th Circuit, we're going to ask for a stay until they can fully rule on the merits. Judge Battalion, we were asking him for 14 days just to give us time to get to the 8th Circuit. He chose to give 7 days before it became effective.
How confident are you you'll get that stay?
Well, in light of the fact that they ruled back in 2007 that it was unconstitutional, and also I think the 8th Circuit would be well aware of the chaos that it creates for states, I'm hopeful. I don't know if I would say the word confident, but I'm hopeful.
Can you reiterate what kind of chaos possibly create?
Well, yeah, and you can see it now. Different county clerks are saying whether they will or will not grant marriage licenses. If you had a situation in which people were allowed, or county clerks decided to grant those licenses, and people went through with ceremonies, and then the U.S. Supreme Court or the Eighth Circuit comes back and says that Nebraska's law is constitutional, you've created a gap in time in which people were getting marriage certificates that weren't constitutionally recognized in the state of Nebraska. So.
What do you say to those same-sex couples that call Nebraska home, they want to stay here, but don't have those same rights as you and I have?
You know, I recognize, and the governor and I have talked about this, we recognize these are very, very difficult issues. But I think the rule of law for both our U.S. Constitution and Nebraska Constitution says there is a process to go through. And sometimes there's winners and sometimes there are losers. There's some who are push the cause and the cause is embraced by the state or by the country, and others whose causes are not embraced. I don't think we can dictate our laws based upon the emotional arguments of a certain class of people. We have to go through the proper constitutional process. And I know that's difficult because it has individual impact. And frankly, you look at the pleadings in this case, they're full of all kinds of emotional claims. But we can't have our law dictated upon emotional claims. It has to be dictated upon sound constitutional reasoning. Otherwise, we're subject to the emotion of the moment.
Can you address the argument that the courts are the proper venue for this because this is something that shouldn't be addressed by voters because it addresses what a lot of people say is a fundamental right?
I don't think anyone can argue that until the Supreme Court declares it a fundamental right. And I thought it was interesting that Judge Battalion would not go that far. He chose not to make that decision that it was a fundamental right, and that's important. Will we eventually allow, as I believe the constitutional framework provides for, Nebraskans to vote on this matter again? A lot will have to do with what the U.S. Supreme Court does in June.
How does Judge Battalion's, how you read it, how does it differ from other federal judges' rulings in this matter?
Honestly, I found the opinion a little bit difficult because difficult to follow. And we've had a lot of debate about it since it came out this morning. The opinion cites a lot of cases. As you see, there's footnotes citing a lot of U.S. District Court cases, cites prior U.S. Supreme Court cases. That's fine to set up that different framework, but then I believe the opinion fails to put those pieces together in a constitutional analysis in the end. Is it a pure equal protection clause argument? Is it a pure due process argument? It at the end, and we've actually had those outside of our office look at it and see if they can follow this pattern, and it's difficult at the end to see. It felt like it was more of an outcome-based decision, that you take a few cases from around the federal circuits and district courts to seem to reach an outcome, but a step through the analysis is difficult to follow based upon my 3 readings of it so far. If there was a gap in time where there was no stay, I could see a county clerk being concerned that it may be reversed by the Nebraska or the U.S. Supreme Court. We in the Attorney General's office are not in a position to advise county clerks. They have to rely upon the counsel of their county attorneys. The other thing that's somewhat difficult about it, if you want to get into the weeds, Rule 65 of the federal rules basically say that an injunction applies to those parties identified in the lawsuit. And in this particular case, certainly they have not identified all 93 county court clerks. So there's a question of whether or not the court's injunction of temporary injunction would apply to those not identified as clerks. My hope is that we don't have to get into those legal type of arguments, that the matter will be stayed until we get a full ruling on the merits.
With that being said, what will the state do for the marriage certificates if there's no state?
Well, the issuing of the certificates is a responsibility of county court clerks. As far as forms to be provided, we'll address that when it arrives.
Governor Ricketts, you mentioned that 70% of Nebraskans identify married between a man and a woman. How up to date is that statistic? And if it's not, what's the most recent numbers that you have?
Well, the most relevant numbers are that 70%, because that's the last time we voted on it. And as the Attorney General was pointing out, that's the appropriate way to amend the Constitution. And as constitutional officers, he and I are both sworn to uphold that Constitution, and that's what we're here today to tell you, is that that's what we're going to do.
Do you believe those numbers have changed, though, in the last decade?
The only numbers that count are the ones that actually happen when we vote. And I can tell you from talking to people all across the state that Nebraskans I have spoken with believe that traditional marriage is what they're supporting.
History shows people have been wrong before what they want, women's rights, segregation. So why use the argument that this is what the people wanted when times like segregation and women's rights, government have made decisions without the people's vote, and when in fact the government was right?
Well, again, I agree with the Attorney General that the appropriate way to address this is through the constitutional process, and that's the way we addressed this in 2000. We passed a constitutional amendment. It's the law of our state, and that's what we're going to uphold.
So in this hypothetical world where the Supreme Court doesn't say it's a fundamental right in June and it goes back to the vote of the people of Nebraska, what would be your leadership position on what people should vote?
Well, I don't really get into talking about hypotheticals. We'll deal with the facts we have on the table, which is in 2000, we passed a constitutional amendment that said that by 70% of the people that said marriage is defined between one man and one woman, and that's what the Attorney General and I are here to defend today.
Have you made contact with the other states that have cases pending before the Eighth Circuit Court? And are there commonalities in what you may be arguing?
We have not. The South Dakota has an appeal to the Eighth Circuit in Missouri. We have not had discussions with them about that or the nature of their appeal. It will be interesting what case would be argued first before the Eighth Circuit, and I can't tell you how that process will work.
Do you know if it would be appropriate, I mean, do you know enough about the other states to know if it would be appropriate to have them work together as one, that way you do it all in one block, or?
I don't, but we will be in touch with them and finding out where they're at procedurally, because we're anxious to know the effect that it might have on our stay.
And timing-wise, this is to be argued before the Eighth Circuit Court not all that long before the Supreme Court would have to rule. Would you anticipate hearing something, having a decision from the Eighth, or?
You know, Martha, it's always hard because you don't know the extent of their caseload, you don't know the extent of their ability to get a ruling out quickly, so I would be purely guessing at any time frame that they'd be able to do that.
Governor, on with the foster care, allowing same-sex couples, or unmarried couples, I guess, to adopt, not adopt, but to take on foster care. Why did you decide to do that? And does this at all show any softening of your views on same-sex marriages? Or?
Well, Andrew, I think what you're referring to is a memo that we've taken off the website. It was 1-95, indicating it had been put up in January of 1995. And that memo was not in line with the policies, or the procedure rather, that we were following at HHS, and as part of an overall review of regulatory matters, we're reviewing that right now.
Do you know why they weren't following it, or I mean, would you want them to follow it?
With the evolving of, leadership and so forth, it's very difficult to pinpoint exactly when they stop following it, but certainly it's one of the reasons why we're going back to review that.
Here's time for about one more question.
Are you worried at all? I mean, there's just over 2,000 same-sex couples in Nebraska who are cohabitating. Are you worried at all about losing those tax-paying citizens and having them move to other states where their lifestyle is more recognized, I guess, if you will?
Certainly, I know this is a difficult issue for many families, and it's certainly an issue for my family as well. However, what we have to do is follow the rule of law. That's one of the great things about our country, is that we have a rule of law, and our Constitution clearly defines the definition of marriage between one man and one woman, and that is what I'm here to uphold, and that's what the Attorney General is here to uphold. Well, again, thank you all very much. Appreciate you coming out here this afternoon. I'm sure that we'll have a chance to see you all again real soon.